Hi everybody and welcome to Psychology and Law. My name is Dr. Joshua Behl and I'll be your professor this semester. This is the first lecture in this course and it's going to be a broad overview of what exactly psychology and law is, as well as what the general overview of this course is going to be. As always, if you need any questions, feel free to email me either on Canvas or through normal email, which you can find on the syllabus. So let's go ahead and get started. What is psychology and law? Really, psychology and law is a very, very broad field. Any application of psychological research methods, theory, and or practice to a task faced by the legal system could be defined as psychology and law. Now, generally, psychology and law has a lot of different names. Some people call it forensic psychology, some people obviously call it psychology and law, there's legal psychology, psycholegal research, and a host of other names, and they all pretty much mean the same thing. Now, this is probably going to surprise some of you who have a different idea of what forensic psychology is as mental health counseling or clinical psychology in a jail or a prison, and that is part of it, right? Because that still fits that definition of any application of psychological research methods, theory, or practice in the legal system, right? But it is much more broad than that. It could include things like eyewitnesses, false confessions, lie detection. There's a lot of things that psychology and law is. How is psychology actually relevant to law? There's a lot of ways that it is, right? And we're going to talk about all of those over the course of this whole semester, right? Motivation, what causes behaviors of criminals, is a psychological theory, right? Motivation in and of itself is a psychological concept. And so why do criminals commit crime? There are psychological theories. For those of you who have taken criminology or criminological theory, you know that there are psychological theories to crime and deviance, right? Persuasion. Obviously, persuasion is a psychological theory. Lawyers and witnesses try and do that primarily as their job. It's their job to persuade a judge or a jury, right? It's a juror's job in deliberations to persuade another juror to agree with their side, right? And so persuasion is used quite a bit in law, and it's also a psychological concept. There's perceptual and cognitive processes that are also present, right? How accurate are our eyewitnesses? What affects the likelihood that an identification will be accurate? Do jurors understand expert testimony, right? These are all perceptual and cognitive processes that are relevant in psychology that we see all the time, right? Memory, accuracy of memories, are psychological ideas that are also prevalent in our criminal justice system. And there's also decision making, right? When do jurors believe or not believe a witness? How do jurors work together to reach a verdict? Group decision making, individual decision making, decision making on the order an attorney will present their case. All of these things are psychological, right? And you can see how some of these things are even tied together, right? Like decision making can be tied to persuasion, such that an attorney is going to structure his case and make decisions on how to structure his case to be the most persuasive as possible, at least in theory, right? And so this is all the different ways that psychology is relevant to law. Now, we need to start with a very brief history of psychology and law, right? Because psychology in and of itself is a fairly young field. Criminology is even younger. And psychology and law is really pretty young as well. The beginnings of psychology and law were in the late 1800s and early 1900s. Hugo Musterberg wrote a book called On the Witness Stand in 1908 that kind of set the foundation for what many consider forensic psychology today. Although Musterberg was not the sole researcher, he did push for research in the legal area. But he was not always well received in the legal area, and in fact, for quite a while was very poorly received in the legal area. Here's a quote, experimental psychology has reached a stage at which it seems natural and sound to give attention to its possible service for the practical needs of life. So instead of doing research like people did in the 1800s and early 1900s as just kind of a knowledge for knowledge's sake, I just want to know what's happening, and so we'll see what happens. Hugo Munsterberg said, no. Why don't we actually use all this stuff we're learning and actually apply it to the real world? Apply it to practical needs of life. And the way he suggests doing this is apply it to this practical need in the legal field. So he was, like I just said, was not very warmly received. And so there was this great period of inactivity from the 1930s until the 1970s, right? And the legal community resisted and avoided really incorporating psychological research into the court system, right? This is not an indictment necessarily on the field of law or attorneys in general, but when things have been done the same way for hundreds of years, we don't tend to actually look for new innovative ways to change things. We just say that's just the way it's always been done, so that's the way it should still always be done. For those of you who've taken sociology of law, you'll remember that law has this tendency toward conservatism, right? It has this tendency to be very slow to change and to be very kind of entrenched in its area, right? And so there's this period of inactivity for about 40 years where nothing really happened. And then in the 1970s, there is this huge resurgence of psychological research in the legal system, right? And there's this renewed emphasis on field studies. And this helped actually establish the relevance for social psychology in general, right? So where we are today is that psychologists are in almost every subdiscipline examining legal issues, right? And so we have psychologists that examine police decision-making, courts, corrections, eyewitnesses, juries, attorney decision-making, judicial decision-making, plea bargaining decision-making. We have psychologists that are examining every real subdiscipline in our legal system. Also, the American Psychological Association, or APA, actually developed a whole division, Division 41 of APA, the American Psychology and Law Society, which I happen to be a member of. It is actually one of the top grossing, as far as finances at least, divisions in APA. Its journal has one of the highest impact factors in APA, and it is a whole subdivision that has its own conference, its own journals, its own experts that literally just study for their whole careers psychology and law issues. Now, we talk about psychology and law as if these are just terms that we're all okay with and comfortable using. But we need to differentiate, right? So if we were to compare psychology versus law, issues in the emergence of these two are present, very heavily present, right? Psychology is the scientific study of human behavior, right? We want to know why it is in psychology that people act the way they do, make the decisions the way they do, respond to stimuli the way they do. Law doesn't care about the why. Law, its main attempt is to control human behavior. Again, from sociology of law, you should remember, or even intro, that law is pretty much just social control. There are certain behaviors we don't want people to do, and so we are going to outlaw those and try and make sure people don't do those behaviors. If they do those behaviors, they get punished for them, right? However, historically, law and psychology also differ a lot in methodology as well as in values. And we'll talk about those and we'll see a comparison here in the next slide, right? Psychology is very, very empirical, right? The world can best be understood by research, right? We need to research what we think we know to confirm that what we know is actually accurate. Law is very opposite than that. Law is doctrinal. The world can be best understood by precedent. What happened before is what's going to happen again, and we need to have consistency, right? In psychology, we deal with probabilities, right? These are quantified maybes. If you think about it, right, we have effect sizes in research, which means that the independent variable affects the dependent variable this much. So if you have an r squared of 0.3, 30% of the variation in the dependent variable is caused by the independent variable, right? And so we don't say stuff like, if you grew up in an abusive household, you will become a serial killer. It might help push you to become a serial killer, but we don't say guaranteed this is what's going to happen. Law is very different than that. It deals in absolutes. You are either guilty or innocent. You are either insane or sane. That's it. There's nothing in between with them at all, right? Psychology is also nomothetic, which means what happens in general. We look about broad things, right? Overwhelmingly, this is what happens in eyewitness identifications. That's not saying that's what happens in every eyewitness identification, but overwhelmingly, cross-race identifications are bad, and you'll see that when we talk about eyewitnesses later this semester. Law deals with the idiographic, right? What happened in this specific case? I don't care about probabilities. I don't care about what happens in general. I want to know specifically what happened here, right? Psychology is very objective. We integrate all the findings into one refined view of the truth. That's why we have lit reviews at the beginning of papers, right? Here's the state of the field on this topic. I'm going to try and add to the state of the field with this idea, and then integrate that new finding into the new state of the field at the end in the discussion section, right? We want to get a full and complete view of the truth and push that forward. Law is very adversarial, right? Your attorney represents one viewpoint, and that's it. The attorney does not work, or shouldn't at least, work with the other side, right? The attorney's job is to represent the best interest of their client, even if that client is the state, and fight as vigorously for that client as possible. It doesn't matter what the truth is. Legal truth and factual truth are very different things. And then psychology has a very proactive orientation. We know that, I've already referenced eyewitness identifications, we know that there are certain things that might cause someone to have a bad identification or have a mistaken identification made, and so let's go out of our way on the front end to fix things so that on the back end the procedures work better. Whereas law is very, very reactive. There was an illegal search and seizure, therefore we'll go ahead and drop the charges, as opposed to saying, why don't we come up with ways to avoid that illegal search and seizure from happening at the beginning. The legal system has a lot of criticisms of psychology as well, and some of these are valid criticisms, right? There's a lack of ecological or external validity in psychological research, right? A lot of people, and I work as a trial consultant outside of my teaching here at Flagler, and a lot of things that attorneys will say to me, or even attorney clients will say to me, is, you keep talking about this research, but the research was done with 100 undergraduate students in a lab where it is in no way like a real court case. And so you can't tell me that the results of that study are actually valid because it's in such a different situation than what this jury that we're going to have in this case is going to hear. And that's a very valid concern. And it lacks real-world applications. And so one of the things that psychology needs to do is maybe be better at having more ecologically valid stimuli, right? But that is one of the legal system's criticisms of psychology. Also, they claim that they go beyond the data to make moral judgments, right? And for example, in competency hearings, we will go beyond the data and say, well, it seems like this person may have been insane, and so we think that they should be found not guilty by reason of insanity. And the legal system has a really big issue with that. It says, no, it's not your job to make the moral judgments. You just tell us what the facts say. There's also a criticism that psychology intrudes upon the legitimate activities of the legal system, right? For example, people might hire expert witnesses that are psychologists, and experts, when they get paid, are usually trying to persuade when their job is actually to just inform. Now, again, you could argue that might be a bigger issue of the adversarial system as a whole, but these are some of the criticisms of psychology and law, right? So that begs the question, can psychology or psychologists actually be successful in communicating research findings in court? And the answer is a resounding yes. In 2001, there were eyewitness guidelines that were passed, that were given to the Supreme Court, that helped pass a lot of reform in eyewitnesses. And a lot of states now, including Florida, have significant eyewitness guidelines because of all the psychological research that's been done to show the issues with eyewitnesses. A more famous example is Brown v. Board of Education. For those of you who don't remember, that's the case that dealt with desegregating schools in America, right? The American Psychological Association actually submitted an amicus curiae brief, which is a friend of the court brief, examining the psychological consequences of segregation, and actually showed that there is actually severe psychological deficits in minorities that are separated from the majority, and that it does have a negative impact on their education as well as their psychological well-being, and that separate but equal, or Plessy v. Ferguson, was actually a huge mistake that caused a lot of conflict for minority students. And so Brown v. Board of Education actually did a lot to help, the amicus brief in Brown v. Board of Education did a lot to help push out segregation in America. But with that all being said, our differing paradigms continue to be a problem. As I referenced, even today when I work as a trial consultant and I try and explain how research works and what the research suggests, if the research disagrees with an attorney's thoughts on a case, they tend to be very, very resistant to that research and think that I'm just full of it for trying to talk about this research to them. Now, the influencing policy with social science research is hugely important, right? One of the things that psychologists will try to do is influence legislature, right? And we can do this by lobbying, right? Going to Washington or going to Tallahassee and saying, hey, legislatures, here's how this works, all right? We need you to understand what some of these issues are so that you can help pass laws that are better, right? Also, some legislators actually place psychologists on their staffs and say, okay, I want to tackle criminal justice reform. Let me get a legal psychologist on my staff who understands all this research so they can help explain to me what the research is on criminal justice issues so that we can help push for reform. And then also providing expert testimony on legislative hearings also is something that happens. Sometimes experts will get called in to legislative sessions to give a speech on the issues of false confessions or eyewitness testimony or whatever the case may be. And that's how psychologists can influence the legislature. Now, there's also ways psychologists can influence the court. And psychologists can influence these courts in a couple of ways. One is by an amicus curiae brief, which I've already referenced in the Brown v. Board of Education case. This is an argument, essentially, that's made by a third party to dispute a third party to the dispute that seeks to inform the judges on matters relevant to the dispute. And there's two different kind of ways these amicus curiae briefs can be functioned or formed. One is a science translation brief, and this is intended to be an objective summary of the research, right? So here's the state of the field on this topic, right? So if there was a sketchy eyewitness identification that was made, here is what the field knows about eyewitness research. Or eyewitness issues, and so it can help point justice in the right direction. We're not going to give an opinion on this at all. We're not going to tell you anything else but just what the field says. Use this information to apply it to this case and make your own decision, right? And then there are advocacy briefs, and these take a position on some legal or public policy issue. The Brown v. Board of Education brief was very much an advocacy brief. Segregation is bad. Here's why it's bad. Here's why it needs to be overturned. Right? It very much took a side and pushed something forward very, very clearly. All right? And so this is, the end of this lecture. This is pretty much what is psychology and law. And this is what you should be expecting to learn about the rest of this semester. And there are a couple things I do want to point out to you here at the end of this lecture as you move forward in the semester. There are discussion posts that need to be posted. The due date for those is every Friday. You'll notice that they're open until the following Sunday, even though they're due on a Friday. And that's because I understand that life gets in the way. You can turn in late work, up to 2 days late, but points will obviously be deducted. Please don't call me, or email me on the Wednesday after something's due and say, hey, I'm so sorry, life got in the way, it's been 5 or 6 days. The great thing about an online class is you can log in at 2 in the morning and turn something in. You can log in at 6 in the morning before work and turn something in. And so I'm not going to be as flexible with that as probably some of you would like. There's also going to be quizzes randomly given throughout the course of the semester, as well as 2 exams that need to be taken. There is no textbook, all right? There are journal articles that you're expected to read throughout the course of the semester. If you have any questions about those journal articles or anything having to do with those journal articles, please also email me and let me know that. I'm looking forward to a great semester, and as always, if you need anything, please let me know. And if you all happen to be watching this before the 4th of July holiday, I hope you all have a very happy holiday.